lawyer in the sense I don't go to court. I'm not a practicing lawyer. But I have experience in the courtroom in the sense I worked for six to 7 years as a reporter from the Supreme Court for the Supreme Court cases, the journal Supreme Court cases. इसके लिए मैं रिपोर्टिंग करती थी, इसलिए रोज़ मुझे कोर्ट जाना पड़ा और जहाँ लॉयर्स नहीं जाते हैं वहाँ भी मैंने जाके कोर्ट क्या है देखे आई हूँ. So I have a fair idea of what the court system is about. मैं एक एकेडमिक लॉयर हूँ, मतलब एक्चुअली एक डिसीजन लिया था पहले शुरुआत में. दो चीज़, एक ये है कि हमारी इन इंडिया वी डोंट अंडरस्टैंड जूरिस्प्रूडेंस. मतलब हम ये आइडियाज जो है, लॉ एक आइडिया है, उसका मतलब क्या है, व्हाट डज इट मीन इन इंडिया, व्हाट डज इट मीन इन अ कंट्री जहाँ पे ब्रिटिश लोगों ने आके लॉ बनाया था पहले इन द फॉर्म इन विच वी हैव इट टुडे एंड हम उसको कंटिन्यू कर रहे हैं. सो व्हाट डज इट मीन, व्हाट डज दिस आइडिया ऑफ लॉ मीन. लॉ एक इंस्ट्रूमेंट है, एक हथियार है, कि एक नॉर्म है जो एथिक्स हमें बताता है. व्हाट इज इट, व्हाट इज द आइडिया ऑफ लॉ. वन आइडिया वाज टू फाइंड आउट ये क्या चीज़ है. सो आई डिड नॉट गो टू प्रैक्टिस. सेकेंड रीजन फॉर नॉट गोइंग इनटू प्रैक्टिस, मेनी ऑफ यू आर प्रैक्टिसिंग लॉयर्स, आपको पता है कि व्हेन यू एंटर द कोर्ट रूम आपको येस माय लॉर्ड, नो माय लॉर्ड, येस व्हाटएवर मिस्टर जज और व्हाटएवर कहना पड़ता है. तो उसमें हमारा दिमाग में भी एक ट्रेनिंग हो जाता है कि वी हैव टू बी सबसर्विएंट टू द इंस्टीट्यूशन. बाहर आके जितने भी गालियाँ देते हैं, अंदर जाके ये ज़रा सर झुकना पड़ता है. So I realized that you can't critique a system जब हम उस सिस्टम के अंदर हैं, because you have to follow the rules of the system. So with these two in mind, I didn't go into the court to practice, but these two are important things for lawyers to understand what is happening. So So certain things I'll just start off with. The first thing is, I think in a democracy and in a constitutional democracy, obedience is not a virtue. जो कहते हैं उसको सुनना ये अच्छी चीज़ नहीं है. That's not our job. As a democrat, our job is not to obey instructions that are given by the state, that are given by various agencies. It is to keep the state in check. As people, as lawyers particularly, keeping the state within the constitution, within the powers that they think they have. You have to limit the powers of the state. That's the job of all good constitutional lawyers. So what do I mean by this? See, sometimes in the beginning, till about Golaknath case, in the early years, it was presumed that the constitution gives the state powers to act in various ways. So if you look at the early cases, they used to A.K. Gopal and all that, they can pick them up, they can put away in preventive detention. All of that was allowed because they said that the state needs to function. And the state has certain powers under the constitution. After Golaknath, that means from at least 1969-70, all that has changed. Human rights has been possible because it changed. How did it change? From being about the powers of the constitution, it has become now the powers of the state. The constitution today is about the limits of power of the state over a people. So it took us some time to understand that ये state का power का मामला नहीं है. It is about limiting the powers over a people. People have freedom. If you have to curb that freedom, it can only be done in very limited ways. हमें ये भी पता है कि ओवर द इयर्स फंडामेंटल राइट्स, हम सब जानते हैं फंडामेंटल राइट्स के बारे में, और उसके साथ जो रीजनेबल रिस्ट्रिक्शंस आता है उसके बारे में भी हमें पता है. बट लाइक कनबिरान टोल्ड अस, पहले फंडामेंटल राइट्स था, लेकिन वो फंडामेंटल राइट्स वो रीजनेबल रिस्ट्रिक्शंस ला कर नाउ यू फाइंड दैट रीजनेबल रिस्ट्रिक्शंस आर फंडामेंटल. जो बचता है वो रीजनेबल रिस्ट्रिक्शन सब इस्तेमाल इम्पोज करने के बाद जो बचता है वो फंडामेंटल राइट्स बनते हैं. एंड वो फंडामेंटल राइट्स हम लोग, फॉर अस टू एक्सरसाइज दोज फंडामेंटल राइट्स, वी हैव टू टेक परमिशन. So if you have to do a protest and you have to go out onto the street, you have a right. You have a right to associate freely and assemble freely without arms. That is a fundamental right. But today you have to go to the police station, inform them, then they will tell you whether they give you permission or not for you to collect, gather together. This is completely contrary to the idea of the Constitution and what was given to us. This is contrary to the idea of freedom. It's only lawyers who have both the ability, and others may also have the ability, but to have the access to the courtroom and to understand the courtroom and the court system, who will be able to articulate this and make sure that we get back our fundamental rights. We have a long way to go because we have allowed many of our fundamental rights to become very narrow and we've allowed it to shrink. We now have to fight back to get back our fundamental rights. They don't exist. Why? Because reasonable restrictions have taken over. So as I start, I also want to say another thing that Kandabiran said, which is very important for many of us. He says there is a book that he wrote, it's a collection of his essays called Wages of Impunity. Every lawyer I think should read this book. Because it tells us, you read it, it changes your response to the law, it changes your response to the Constitution. In that book he says that it's a very hard journey, very difficult journey that we have to make from being a slave to becoming a subject, and then from being a subject to becoming a citizen. Citizenship is not something, just because they say you are a citizen of India, we don't get citizenship. We have to fight for the various incidents. What does it mean to be a citizen? So we have to fight for many of those aspects of achieving citizenship. Very often we get some elements of citizenship, we don't get everything and we keep battling for the rest. But to retain even that is a struggle. So all manner of things can come. Today I think nationalism and patriotism have taken over from citizenship totally. So what are these elements of citizenship that we are losing when we are just saying that I'm tired of living by instruction. They'll tell me, stand up, we are playing the anthem. Sit down, you have to hear what we have to say. Take your kachara and put it in this dustbin. Sure, we need to do, putting kachara in dustbin, but we don't need to be instructed on everything. So there is a way in which the idea of the citizen as an autonomous being, who's part of a community, and that community is not only the country and the nation and the state, but of multiple kinds of communities. All that is getting lost in these various kinds of things that are happening. So citizenship, even when we achieve some elements of citizenship, and some people achieve more, fuller citizenship than others, even there it is difficult to retain that citizenship. So we have to keep on and on, it's like sometimes you have to keep running to stay in the same place. And you certainly have to keep running fast, not to slide down. So this is part of that exercise. So when they said activist lawyering, I was happy to be part of that, because activist lawyering happens in many places. It doesn't happen only in the courtroom. But the courtroom is an important venue. It's an important arena where lawyers distill what is being said in other circles and takes it before a court and asks it to do things which will preserve the freedoms and rights of people. It's a very important role. And to do that, the lawyer first has to understand what that freedom is. What the constitutional value is which is going to be taken into the courtroom, what that human value is that we are asking to be taken into the courtroom. So if I were to just give one, lawyers too, like other members of this whole judicial community, have certain constraints. So you'll find that lawyers, when they go to the courtroom, they'll say, listen, do you want your remedy or do you want your politics to go to the courtroom? We have them say this very often. So when the question that this asks is, for instance, all mobile phones should be banned, what do you think? And then Paytm can't count in, that will be a good thing. So it's really about understanding some of these notions. How do you take it to the courtroom, and what is it that the lawyer does in that context? Because the lawyer first has to have a sense of what is freedom, what are rights, why are people asking for these rights, and the lawyer is trained in black letter law. So they'll say follow the law. What do you do if a law is something that is, that has adverse consequences for people? How do you take it into the courtroom? What if the power that is given under a law is adverse, is contrary to how people live their lives? So let me give you some simple illustrations that help me understand it. So you have two people going to the court and saying that two women going to the court and saying, I want custody of my child. Right? A woman is entitled to custody of her child. But when you go to the courtroom, you're going to face paternalistic, patriarchal bias. The judges will feel like, no, this woman is going to be on her own. How is she going to be able to take care of the child? It's better that the child goes to the father, because the father's mother will take care of the child. And the father will be earning and will be bringing money. So it's better that they go to that family than that the child stays with the mother. So the lawyer then advises the woman, the mother, and says, when you go to the court, this is the petition I'm going to file on your behalf. I'm going to say, mother is very caring, mother has nurturing ability, at this age the child needs the mother, and the father can't do many things that the mother can do. And the woman turns around and says, that's not true. I'm not going to leave everything and come out. It's not like I'm the only one who's going to. The father too cares about the child. It's not about the father not caring or not nurturing or not taking care. I am getting a separation from the man, and I am saying that I have a right to have the child with me. Why does it have to be on these terms? There are 100 other terms that you can take into the courtroom. This is not my politics. My politics is not to say that mother is nurturing and father is bad. Then the lawyer turns around and says, listen, do you want your child or do you want your politics in court? And then you have to make that choice. So how do you then do lawyering that does not destroy your client's politics, that does not destroy the way in which your client wants to be represented in the courtroom? And I'll give you one, once some years ago, about 20 years ago, I collected cases from 1920 to 1950. Just looked at all the cases. I was actually looking for something else, but when I was looking through each page in AIR, from all the high courts, I found that women kept coming up in many places. So I said, Acha, this is interesting. Women were not the petitioners. Women were not the respondents. But women were represented in the cases all the time. So I said, let me just take a look and see, who are these women? How did the judges talk about them? And after a lot of, about 500 cases came out of this, and then after a lot of trying to figure out what is it that they are saying, finally, and I was able to distill it down to about 110 cases. And it's very interesting what emerges. The judges seem to feel that there is this concept of a man who's, all you lawyers know about the reasonable man. Right? In tort law, you have reasonable man. Have you ever heard of a reasonable woman? Because reasonable women don't exist. We don't bother with being reasonable. We have better things to do than being reasonable. But the point, and there are reasonable expectations of the reasonable man and the reasonable woman. So after doing a study of all these cases and seeing what happens, I found that it's actually easier to be a woman than to be a man, because men, all kinds of things are expected of them. They are expected to be able to control their wives, their children, all kinds of absurd, and if you're not, then you're not a man at all. And I'm like judicially thinking like this. But about the woman, they talk about the woman to say that a reasonable woman is always a wife. So the people who are, the women who are unreasonable and therefore not wives, for instance, women in prostitution, they were not seen as reasonable women. More rights were recognized in them than in the reasonable woman. Because a reasonable woman has to conform to the stereotype. A lot of the time in activist lawyering, you have to force the breaking out of stereotypes. And that's the hard task that you have to confront. Of course, the article is out on the thing and there's a whole list of things. A reasonable woman, for instance, doesn't have children. She only has her husband's children. So it's a range of things in which, and it helped some of us, when we discussed it later, to say that these are the stereotypes that we want to break. So that's one kind of thing. The other thing is, what do you do when a law is bad? We say normally, I have actually found that human rights people follow law much more than others do. Because we are aware of the law, we are aware of the consequences of breakdown of the law, and human rights people are not actually asking for anarchy, they are asking for change. So there is no great desire to break the law. In fact, we had one hilarious experience one night after 12 o'clock. We were two sets of people in two vehicles coming back from a dinner and discussion with the professor. On the way back, there were signals. There were 6 signals along the way. And both the vehicles stopped at every signal where it was red light, and I think 5 out of the 6 were red when we crossed it. So we waited, and then when the light changed, we moved. After the second and the third signal, we suddenly realized that everybody else was just breaking the signal and going, and we were the only 2 who were not breaking the signal. And it seemed very strange to us that people who work for human rights are often treated as if they are criminals themselves. Whereas we are in fact the people who respect the law the most and ask other people to respect the law too. So that's one element of what we do. But there is another element where the law itself is bad. What do you do when the law is bad? So there is the idea of protest, the idea of disruption, and I think in over a period of time, one of the things that lawyers have had to learn is how do they represent clients who are demanding changes through protest, through dissent, through ways in which the state thinks the state is being attacked by people. We know now that dissent itself is seen, and it's not only with the Modi government, it started before. P. Chidambaram was a great votary of this, of clamping down on people. In fact, in the early years, if you remember, he had suggested that there should be a strafe bombing in Chhattisgarh so that the Naxalites can be flushed out. Never mind if a whole host of other, Vietnam kind situation. This is a very common state response to people who are active, who are active on the ground and who are resisting what the state is doing. And very often what the state is doing is wrong. And so you have to resist and protest. When we do that, they turn around and say that these are people who disrupt the law and disrupt law and order. If we were to just sit back and think, it's strange how we are the people, in fact, who keep the law and follow the law and demand that the state too follows the law. Encounter killings are a classic example. All the time, it is the dissenters from the state, not dissenters from the law, who've been saying that we need a case registered when there is a fake encounter. When there is an encounter, it's an unnatural death. All unnatural deaths have to be investigated. What's the great rocket science in this, no? Of course all of them have to be investigated. But what is actually done? The person who gets shot, the case is filed against that person. And in criminal law, the case is closed once the person is dead. So the person who actually did the shooting becomes a victim of that shooting, as far as that FIR is concerned. We have to work at turning all these around. So in activist lawyering, I find that the first stage for us, for each of us, is breaking down stereotypes in our own minds. I must tell you that many times going to a lawyer can be a deeply frustrating exercise, because they'll say, what is wrong with this? What is wrong? And I've worked on the UID case for the longest time. Initially it was very difficult. Lawyers would say, but they are saying that that Aadhaar card, that it is being given for welfare. Why are you objecting to it? Oh, it's only a matter of privacy, is it? No, it's much more than a matter of privacy. So to explain it to the lawyer and to say what happens to people on the ground when a thing like this is imposed on them, and what happens to that power of the state over people, it takes time, because lawyers are used to looking at the law and going into the courtroom, training what they are doing to the language of the court. The court understands this, I will say it to the court like this. Court won't understand anything else. So you can't go to the court and say, actually I am objecting to your saying that I should stand up when the national anthem is sung. You have to say, no, I am fine with with standing up. We are just asking for further clarifications. So you have to play your game in a certain sense in the court in a certain way, but that might destroy the very purpose of the case. So in human rights lawyering and in an activist lawyering, you need first to break down the stereotypes in your own. Henry, you've got your name here. Okay. So in activist lawyering, lawyers have to break down these stereotypes in their own minds first, and that's an extraordinary exercise that has to be done. The second thing is that there are, if I'll just use the illustration of mass displacement. We know that we've had land acquisition problems forever. And we've always categorized this as land acquisition. It took a long time. In the 80s, till the 80s, it was seen only, till the end of the 80s, it was only seen as a land acquisition problem. So everything was done as if the Land Acquisition Act was the problem. It was the problem, no question. It was a problem in the sense that it did two things. One, it allowed the state to take whatever land it wanted for what it considered a public purpose. So that per se was a problem. But it had another problem, not with what was in the law, but what was not in the law. What was not in the law? Nowhere did that law say what should be done with people who don't own land, who don't have any legal interest in land, but who are affected when that land is taken over. So the classic case that all of us know about is the Narmada case, Sardar Sarovar. So in Sardar Sarovar, what happens? There are some people who are going to lose land and who will get compensation for that land. Large numbers of people are going to be affected who don't own land, who will then just get washed away by the waters of the reservoir. That's all. You forget about them. So the battle from the beginning was about telling the state that if you are going to displace such large numbers of people, you're not going to be able to rehabilitate them. It is an unworkable proposition. So please do not have such large projects. Now this is not a bad thing for any activist lawyer to work with. But as lawyers, we also need to understand what are the legal concepts that are involved in this. What is the concept? What's the fundamental concept in this? The fundamental concept is called eminent domain, right? What does eminent domain mean? Eminent domain means that the state can take private land for a public purpose upon paying compensation. Okay. But what about land that is not owned privately? Does the eminent domain concept extend to such lands? If I am a private owner of land and the state feels that it needs to take land from me because it's going to apply it for a public purpose, then it can use the Land Acquisition Act and reach me. What does it use to reach me if I don't own land? So the state has throughout felt that if you don't own land, I owe you nothing. If I tell you to leave, you have to leave because you don't have a right to be here anyway. That concept of eminent domain did not get challenged in the beginning. So what happened? We ended up talking to the state saying, you have the power, but please don't use the power in this manner because it violates human rights. Right? As lawyers, we should have been able to see that actually the state does not have that power. Eminent domain power and power under the Land Acquisition Act does not give the state the power to evict masses of people from anywhere. If the state is going to do that, it has to show us where it gets its authority from. We never demanded it because we didn't see it like that. So in activist lawyering, one important thing that I think we need to keep in mind is that we recognize that all of us may be activists along with the activists, but we are also lawyers. So as lawyers, we have to look at legal concepts. Look at the concept, for instance, of adverse possession. We know the doctrine of adverse possession. We know that if it's a private land, then it's for, if you've had uninterrupted access for 12 years, or if it is government land, you've had uninterrupted access for 30 years without anyone challenging your possession, then you acquire a right through adverse possession, right? So adverse meaning nobody else has come in and challenged it of you, so then it becomes yours. In many of the cases in cities, in urban areas where demolitions are happening, people have been there for 25, 30 years. We are not even using the doctrine of adverse possession. We are human rights is a good way of showing what rights people have. But it's not always the only way of going to a court and asserting it, because human rights has to do with compassion. Now if a judge doesn't have compassion, what are you going to do? Then there is nothing at all. We do have the law on our side very often, but we don't use it. Because from being an activist lawyer, we become only an activist, and that's not enough. Sometimes you have to work at being, because the job of a lawyer, when we are working with people in the field is to tell them the various kinds of legal strategies that are available and the various kinds of legal concepts that apply to this. For that, the way we work has to be more than merely telling people to come and report to us, converting them into petitions and filing them in the court. We have to apply it to, which means before taking it into the courtroom, we have to discuss with the people, with the affected people, whether this concept works for them or not. And if the idea that people cannot be just dismissed from a place, cannot be evicted, if that is an idea that appeals to the people on the ground, it is a concept then we take up and take it into the courtroom. And we have not done this. So what has in fact happened is that the state has begun to act as if all of the territory of India belongs to the state. Those of us who are in different places are there as long as the state allows us to be there, and the state can take it over any way it wants. The first thing, like I said, about constitutionalism is it's not about the power of the state. It's about the limitations of the power of the state over a people. The sovereignty in this country does not vest in the state. It vests in you and me. It vests in the people of India. So, who asserts sovereignty then? We will assert sovereignty over the state. The state can't assert sovereignty over us. But we have foregone, we've given up many of these things, and I think it's time we revive them and we reintroduce them, because these are basic constitutional principles. Without these, we really, we are just doing back against the wall lawyering, whereas we don't need to do that. Take another illustration. Sometimes we get, there are situations where people have been victims for such a long time that we fail to recognize when they need no longer be victims. So take the example, and my illustration these days is the Forest Rights Act. The Forest Rights Act is it's got a fascinating history. It's got it's a fascinating piece of legislation because of the way it came, and it's also fascinating because of the problems that are there in the Forest Rights Act itself. So let's just take a quick look at the history of this, of how we came here. When the Forest Rights Act was passed now, they said two things in that which are of significance. They had said many things, but there are two things of significance at this point. One, they said that this law is being passed to set right a historic injustice. It's a very significant statement that they made. To set right a historic injustice. The second thing they said, they didn't say that we will give you pattas or we'll give you rights they said we will recognize the rights that you have. So what did this together, between historic injustice and recognizing rights, what did it mean? How do we read the law? As lawyers, we need to read the law in a way which is people-friendly, But in this case, we don't have to work too hard for it. Why they did this was because they were acknowledging that people in forest areas had been legitimately there. They had been deliberately made illegal and treated as encroachers over 1.5 centuries. So they were now saying that, we are apologizing for this historic injustice where you people who have a right to be where you are, we have been treating you as illegal people. Today we are just recognizing what has always been your right. So there's a difference between land reforms where you're saying we will give land to the landless, which is a process by which the state has to actually hand over land, and recognition of a right where it already exists. So in the Forest Rights Act, when they are saying they are settling rights, they are not settling rights. Stop, don't allow them to use language like this. Settling rights happened when the British was there and they said that we are going to settle rights in various kinds of ways, and it had to do with revenue collection. Recognition of right is about setting right a historic injustice. So we need to understand that ourselves first. So if we go back, and I won't go back beyond 1927, because in 1927 it was a consolidation of all the earlier laws and regulations that existed in connection with forests. We have the Indian Forest Act in 1927. And it's very interesting because when the Indian Forest Act was brought in, see, today we are hoping that the Forest Department will be able to go and suddenly there will be trees all over the country. Forest Department was never created to generate biodiversity. That is not what they were created for. They were created to protect and manage resources. And at that time, the forest resource was only the tree. So if you look at the training that was given to them in those periods, and there are some very interesting writings of that time. There are two particular people, Baden-Powell and Brandis. Brandis still today is the dada of who they follow for training the forest officers. You'll find that one of the things they say is how you need to cut the resource, use the resource, while still preserving the resource. Because for them, since tree was the primary thing, trees had to be, they had to be regenerated because they kept needing them for the development project. We've come back to a time where for the development project we are looking at the forest. But we've been looking at the forest now to divert it from being a forest. Whereas in 1927, they wanted a forest to be, the coops were important. And they would cut the tree in such a way that it would come back to life so that they could keep cutting it and taking it away. But in that process, what did they do? They did a fencing off of the rights of people. Forest, you may not put a physical fence, but you put a legal fence. And you say you don't have any right nobody has any right here. It all belongs to the state now. And the state is going to decide how this will be used. And nobody can cut a tree. In fact, one of the things we found when we were working on this social forestry was that many people did not have trees on their lands. Because any tree of value to the state would then be marked as a tree of value. If a storm comes and hits and the tree falls, they'll have to answer for why did that tree fall. So they said, there was a kind of disincentive to having trees because then the state would step in and become like a, brooding brother hanging around them. So in the initial years, therefore, it was for protection and management of forest areas. Then we'll just jump a bit, go to 1950, we have the Constitution. Nothing much changes after the Constitution. We go up to 1980. Between 1950 and 1960, actually, there was a large amount of cutting down of trees that happened in protected forests because that was the time when they got freed of the colonial establishment and the new establishment hadn't decided what to do with the forest areas. Then they had to bring back the Forest Act, and there is a whole history of that period. Because when you tell people that it's your resource, today I'm saying, suppose they were to tell you like they've done demonetization, they've done. Tomorrow they can say, okay, whatever money you have, only up to 200,000 rupees is going to be yours, all the rest belongs to the state. The state is acting as if it has the power to do anything anyway. So if they were to do that, then what is the immediate thing we would do? And they give you a 1 week period within which you have to get rid of all the other money or else. You will quickly go and spend all the rest of that money. You don't want to be handing it over to the state. That's what happened with the trees in the 50s. Because they were worried that the state will come in again, fence everything in and again say you don't have any access. They said, chalo lagao, let's take all the trees and cut it down and convert it into our own commerce rather than leave it with the state. So we lost a lot because of the short-sighted policies of the state in relation to the relationship between people and forests, people and trees, people and forests. By 1980, the thinking had changed because the environment movement had begun. You'd already had the Stockholm Convention, and then there was the Silent Valley project that was proposed in India and in Kerala. And in putting a stop to that, Mrs. Gandhi said, you can't allow state governments to make these decisions. We have to take that power away from the state governments. We need forests. We need, much larger amounts than we have now. So we are going to take the decision making away from the state government to the central government about whether a forest can be used for a non-forest purpose. Can you cut it down? How can you use it? In what ways will you use it? So they said we need to shift the place of decision so that it is not dispersed and each state government may end up destroying a lot of forest in the name of development, and that's not acceptable. So what happened? You had a law called the Forest Conservation Act. Now, as lawyers, we should be able to read it and tell people that, and we know as lawyers that when you say conservation, it doesn't mean that conservation is the objective. You say Forest Conservation Act, actually you read that law, it is not about conserving forests. It is about shifting the decision from the state government to the central government so that the central government can now decide how to divert forests to non-forest purposes. So why did they call it the Forest Conservation Act? If they don't intend even to conserve forests. It's just that we will be better decision makers than somebody else. Now we know from because in the UPA 2 period, a lot of people followed up on how many projects were actually rejected, how much was permitted. If you look at just take a look at the Mahan project, coal project, and it's up on the website. You see the correspondence between the Prime Minister, the Environment Minister, and the corporates who wanted to get in and do coal mining there. And you see how all this happens by negotiation and not in accordance with the norm of law, but in accordance with the letter of law. So what is a norm of law? Norm of law is that you want to conserve, and that's why you're taking over the power from the state to the center. But what is the pragmatism? They say that it's okay, they're asking that they want to go into a no-go area, let them do their coal mining, the Prime Minister says. And they write saying, we need this, like Vedanta in Niyamgiri. We want to be able to do it, we are going to produce aluminium, we are going to do, we are this great multinational who has come into your country, we are going to produce growth for you. So allow us to get the bauxite from the Niyamgiri hill. And it's so tenuous that the central government can actually give permission in a situation like that. It rests with the central government. And so, although you have various processes, you have the Forest Advisory Committee, you have the Environment Ministry, you have all of that, and yet it can all be overridden by the central government because all of them only have an advisory capacity. So, the Forest Conservation Act, therefore, is not really about conservation, it's about the power shifting from one place to another, and it is about making decisions about diverting land. Another an amusing moment comes later when the court in 2002 or thereabouts is trying to figure out what is a forest. Now lawyers all have to help them figure out what is a forest. What will you do about what is a forest? So they find that whatever has been given, you have large reserves, 23% of the Indian land mass is considered to be forest, legally. But actually, they tell you that about 11% has what you can call a forest, maybe 12%. Now, what happened to this other 11-12%? What is that? You said it's a forest, then how can it not be a forest? Why it's not a forest is because of the law. As we know, law creates fictions, and law has this way of saying, there is a thing that they say when Vinoba Bhave was doing the Bhudan movement, he used, people would donate. Of course, it's not like they donated their best land, but they would donate whatever land it was that they would give. And a law was made, regulations were made about how, who would decide what should be done with the Bhutan land. And obviously they included Vinoba Bhave in that, and they said Acharya Vinoba Bhave will be a part of this. You'll have to consult with him before you make a decision about how to redistribute this land. But what happens if Acharya Vinoba Bhave is not available? Or what happens if, like it happens to all mortals, one day he dies and you've not yet distributed all of that land? So then they say, I forget who it was, but secretary or something of some department will be deemed to be with Acharya Vinoba Bhave. So we can deem anything to be anything in law. So we have to break through some of these deeming provisions. So under the Indian Forest Act, whatever the land was that was treated as reserve forest was presumed to be forest. But as we know, these were lands on which trees existed, which were then cut down and taken away for development purposes. So in many of those areas, you don't have any trees now. You don't have anything in the nature of a forest. But legally and technically, they are reserved forests. So the court then had to figure out now what to do, because there are large tracts of reserve forest which are not forest at all. And there are some forests that exist outside of it, which still, according to the court and according to many others, need to be conserved, to be preserved. So then they said, whatever is declared in law as being a forest is a forest. Whatever is a forest according to the Oxford English Dictionary is also a forest. So in law, how will you as lawyers argue a matter like this before a court? Who are you looking at? Why is it that the argument that there should be de-reservation of areas which are no longer forests but inhabited and where people have various kinds of rights, why was that never argued? What happens when you enter a courtroom? So somewhere you have to investigate and re-investigate yourself on this. Then in the early 90s, again we talk about the creation of legal fictions. In the early 90s, you find that projects are now burgeoning. Everywhere you have projects. So somebody wants a coal project, lots of mining projects, lots of power plants, lots, little car, big car, whatever you have, everybody wants land. And if many of them want forest land, because it's on forest land that under forest land, especially the mining industries, and the power generation companies who want forest land which can be completely taken off. Now this means that trees, we're still focusing on trees rather than on biodiversity, trees are going to vanish. And the assumption in many of our thinking even today is that if you have trees, biodiversity will come back. I don't know how, but we expect it to come back. So the focus has been on trees throughout. Then as this, so when this kept growing, there had to be, in law we know that you have to keep producing legitimacy. If you do something that is totally illegitimate, it becomes more difficult for the state, for the court, for all of us to justify. So what happened, they said, if you are a project who is going to cut down trees, and if you are going to take forest land, then you have to replant the same, double the number of trees. So initially they said if you take 100, if you're going to cut down 100 trees, you have to plant 100 trees. Then they said no, if you're going to cut down 100 trees, you have to plant 200 trees, because then 100 may survive. So they said you have to plant. Now obviously project authorities don't know how to plant trees, they know nothing about trees. They are sitting there making concrete and you're telling them to deal with trees. So they can't do it. Now as lawyers we know that it is not going to work. Then why is it that such a premise is being set up? Because it's a pragmatic, it's not based on principle, it is based on pragmatism. We want the project to go ahead, we are finding an excuse by which the project can go ahead. So you tell them that now you've got to plant the trees. Now nowhere do you say that if the trees don't come up, you're going to stop the project. So that carries on. After a while, about 5 years passes, 6 years passes, then they realize there are no trees and projects are carried on. And project authorities may still be called upon to answer why there are no trees. So now industry is working with the state and saying, no, we can't, how can we be asked to do all of this? We can't do rehabilitation, we can't do creating forests, this is not our job. So they come up with a compromise. They say, okay, you don't have to plant trees, you give us the money. So you create a fund. So lots of money starts coming in, which tells you how much land has been diverted. Lots of money comes in and you have a fund that then gets set up. So you convert it into a fund called the Campa fund. Say it is a lot of fizz and no substance. Otherwise it doesn't make sense to have a name like that. They have a Campa fund. You've all heard about the Campa fund, right? You recently had the Campa law that came in. So that Campa fund starts and then grows and then grows and then grows and there's lots of money. Now everyone is eyeing the money. What to do with that money, how to get your hands on that money. So the battle is no longer about trees, the battle is about the money. So after negotiation, Parliament passes a law. In the meantime, the Supreme Court has been saying that it's not enough if trees are planted from that, but you must also make sure that at least 75% of the trees planted survive. If not, you have to stop the project. Now nobody wants to stop the project, nobody means other than us, nobody else wants to stop the project. And anyone who wants to stop the project is anti-development and anything that they say is anti-national. So we are confronted with all of this when you're working on these issues. So you have the Campa fund now being set up. And under the Campa fund, they decided that a certain amount of money will go to the center and a certain amount to the states. So it's about sharing of resources, which have been created by the destruction of resources. So sharing of monetary resources on the destruction of environmental resources. This is where we've come. So, a lot of words. Right. So this happens on the one hand. The other side, you have a forest officer who takes an order of a court. The order of the court says, no encroacher, you are not to regularize any encroacher without coming back to the court. Right? That's all they say. Some forest officer decides to send off a letter to all other forest officers. From the center, he sends a letter saying, the court has passed an order, and under that order, so he doesn't say that the court has ordered this, but under that order, we are now telling you evict all encroachers. And there is a mass eviction drive that happens in 2002-2003. It is as a result of that that the Forest Rights Act comes in. Now the Forest Rights Act is the first real law that I can think of since independence, where the victim has been made into the master. It's incredible. But because of our habits of thought, we've not yet broken out of that system. I think only the Niyamgiri Dongriya codes have understood this. When the state went to them after that and said, we want to do the Forest Rights Act here and recognize your rights, they said, we don't, so tell us, apply. They said, we are applying to you for nothing, out. We have recognized, we know what our rights are here, we don't need you to come and recognize anything, out. So this idea of settling rights, which is what they are making from recognition of rights, they are now trying to settle rights. It has two consequences, and as lawyers we need to understand that. One consequence is that it limits whatever rights, wherever they can move around and do whatever, it limits their rights. So it makes them property owners from being forest dwellers or from being dwellers of the habitat that they inhabit. The more insidious thing is that the moment a right is settled, they believe that they can now, it can be acquired. If you don't settle a right, if you look at all the debates that have gone on since, you'll have the government saying, okay, now we need a project there, it can't be done until the rights are settled. Why? Because the moment you settle the right, you can purchase that right. You can bring it under eminent domain. So if we understood the concept of eminent domain properly, we wouldn't allow the concept of eminent domain to get into the Forest Rights Act. So I think broadly what I'm saying, I'm sorry to have complicated it so much, but broadly what I'm saying is that as lawyers, it is important to understand what an activist is doing. It is also good to be an activist lawyer, but don't forget your role as lawyers, because we have to do the understanding of the law, the translation of the law, not allowing interpretations to come to that law which will denude the rights of people, and just as a final word, on the UID matter, for instance, I found many groups, particularly those working with migrant workers, would tell me, we are helping them get this, get enrolled for an Aadhaar. And I was telling them, do you know what the project is? Do you know what they are saying they are going to do with it? Do you know where it is headed? Do you realize that it's going to reduce the rights of the people who are going to have this because they want to track you so that they can do what they want with you? And there was no thinking there. Now, if an activist doesn't think about it and is only assisting people, I can still understand it. But I can't understand it when lawyers are unable to think beyond, because these are all legal frameworks that are being set up. It is our business to understand and then start, being with activists as legal activists rather than as just activists. Thank you. Can an activist? Certainly. See the thing. Most certainly. See, the thing is, an advocate can be an activist can become a good advocate. The thing, remember, I'm only drawing this distinction that the way in which power gets structured through law and through legal practice, a lawyer has to understand. So I'm saying an activist, when they become a lawyer, has to be a good activist lawyer. Don't forget your role as a lawyer, that's all I'm saying. In fact, sometimes they make better lawyers than lawyers. The lawyers come with a training, you get trained first in the law and then you understand the problems. You look at the problem through law, which sometimes is limiting. Whereas an activist who becomes a lawyer comes through understanding what the issues are and then becomes a lawyer. But they should become lawyers. I mean, they should be, not become, they should be lawyers also.
But like you just said, that if an activist or a litigant who's standing up for a cause becomes a lawyer, then don't you think that the bench is usually biased because it's he or she is a person appearing, individual appearing person, so that bias is always there as compared to a lawyer, because a lawyer, the bench would expect the lawyer to know the laws and therefore draft well, but that's usually not the case for a litigant.
See, I make a distinction between two kinds of people who go as cause lawyers to the court. One kind of cause lawyer goes as a cause but not as a lawyer. So the kind of drafting that they do, they'll say, people are being treated like this, they should not. For instance, in the beggary cases, I found that, beggars they should not, why are you picking them up like this? They're all poor people and they need to be taken care of. Very, kind of paternalistic, whatever. Now, there is no law in that. When I say an activist becomes a lawyer and then becomes an activist lawyer and should be a lawyer, this is precisely my point. You have to then start engaging with the court like a lawyer does. It is true that people who only do public interest matters do get identified. That's not because their lawyering is bad, that's because the court is finding sometimes they are not sympathetic, and sometimes they feel like this is a burden that's being added on to the court, that, we are doing so many other cases, now this comes in, and just to give you one illustration, we had the National Judicial Academy, we have these training sessions. So one of those training sessions, after it was over, one of the judges came up and said, what is this madam? He had just been appointed 1.5 years before that to being a judge. And he said, what is this madam? When we were lawyers, we were told we have to learn the law. Then when we became judges, we were told that we have to learn the law and we have to learn how to listen. Now you are telling us we have to have compassion. What is this? He was very upset. He felt like it was one more burden on him. Because in cause lawyering, judges don't have the experience. Many of the judges don't understand what it means on the ground. You have to translate it in a way where it will reach their ears. And in some of the things you find, there are judges who want to understand, but their abilities are limited. So in lawyering, a cause lawyer has to remember that the cause is difficult for the judge, and you have to help the judge come to it through locating it in the constitution, in the law, So you can't do it, dehorse this. If you take the law out of cause lawyering, judges are completely out of their depth. So, Sudha Bharadwaj, for instance, she's just been she was a complete cause person. She walks into the courtroom, the court has to hear her today. She knows what the institution is about. She knows what the problem is about. And the courts are not able to dismiss her off because she knows her law. And she argues her law. And forces them, one of the best articulations of how to approach, how we need to think about the court came from Kandaviran. There's a film made on him called The Advocate. In one part he says, he was defending all these Naxalites. Okay, so he went into the court and the judges told him, what is this, Mr. Kandaviran? Why are you, standing up for all these people who have no respect for the constitution and you're fighting constitutional rights for them? He turned around and told the judge, and this discomfited the judge, but it's important. He turned around and told the judge, what is on trial here is not their respect for the constitution, but yours. You have to respect the constitution. So you have to find a way of putting that burden on the judge and making them respond to it. That's what makes for the problem is very often cause lawyers feel that by being part of the cause, they've done their bit. That's not enough. You have to be a lawyer with a cause lawyer. That's the only thing. So it doesn't matter from where you go. And anyway, it's not just the person who's standing before the court who is producing that prejudice. It is the people you represent. And there is a deep prejudice, which is why we are having all these problems now. There is a prejudice about people who refuse to vacate, to get evicted. There is a prejudice against poor people. There is a prejudice against the working classes. I think 2 days ago in Delhi, there was some theft in Safdarjung area, enclave area, and they found that 2 people who had been living the life of beggars had done these thefts. Immediately they called all the persons who were homeless and who were beggars in that area and got them fingerprinted in the local police station. And they say now that wherever you have wherever there's a robbery, we'll first bring them in so that we can find out whether these are, because 2 people did it, right? So I was like, yeah, Vijay Mallya ran away with whatever he ran away with. Why don't you do that to all the corporates? It's ridiculous, but that it will never occur to them to do that. Now, how do you convert this into something that it's a plain constitutional violation? How do you take it to court without their prejudice impacting on what happens in this? That is that's what lawyering is about, no? And you're doing it with a cause in mind.
और कोई सवाल है? Ma'am, I wanted to, you had already told about this thing about judiciary. So I would like to bring to light 3 or 4 incidents. You cited the example of the national anthem case. So there was another prayer made, why don't you start playing the national anthem before the proceedings of the Supreme Court as well as all the High Court and subordinate courts. Supreme Court denied that. Secondly, with respect to the declaration of assets by the judges, the Supreme Court, Delhi High Court ordered, yes, the judges of the Supreme Court have to declare that. Supreme Court judged its own case, that is a violation of the principles of natural justice, and said no, they are not bound to declare their assets. Then also with respect to the medical expenses of judges, it also declined that it cannot be declared through RTI. Then long ago, not long ago, quite means a long time back, the Supreme Court in the Vishaka judgments gave set of guidelines on the Paris principles, etc., etc. But it took so many years, that is late as November, December 2013, that the Supreme Court appointed its own internal complaints committee. So is the Supreme, is our lordships above the Constitution while interpreting them, or you say, I think you throw some light on this?
It doesn't really require an answer, but what it also tells us is that there are entrenched interests. Nobody who's in a good position wants the status quo to change. So none of them, nobody wants to be questioned. I think this time too, after the demonetization, you had the, did you see the AIB, they have a web, they have something up on YouTube. So they have this, it's like they help you laugh, but also to understand. So there's this chai wala who keeps on making chai for various people, and there are conversations happening around him. And at one point, he stops and he says, okay, if you really want that, black money should not be there and you have to deal with it, then why is it that RTI will not, why have you said RTI will not apply to political parties? Because everyone is saying political parties is one of the big ways through which black money is both generated and laundered. So he said, why don't you then allow for the RTI there? And then everyone is silent. Because everyone in power is preserving their own little domain of power. And that is part of the nature of politics which we have to contest. That's what activists are doing all the time. The sad thing is when that space that has been created by activists is taken over in this kind of frivolous way where people who go and say we must have national anthem here and there. I mean, that's the tragedy of it. That kind of devalues that space. But I really think the answer is in your question. It will be like that and we have to keep fighting it. If you're asking, is there any sympathy for it? Oh no, there isn't.